My name is Douglas Ley. I'm an elder law and estate planning attorney located in Janesville, Wisconsin. We are part of a group called Lawyers with Purpose. Currently, there's a little over 200 law firms just like ours in 30-plus states in the United States that do this kind of planning. My background is I was a financial advisor, and I gravitated towards special needs planning for families with special needs children and parents and grandparents that want to make sure that those children are taken care of when they're gone. And I found that there were no lawyers that really worked on that type of estate planning. That was something they would put on their special needs hat rather than have a full understanding of how those rules work, because they're federal rules. So our group of Lawyers with Purpose we practice under federal law with Medicaid, with the Veterans Administration, with Medicare. Those are all very big bureaucracies that have their own rules and regulations. So the reason I do this is because of family. It's all about family. You can see a picture there of my family. You can see I have lots of girls in my family. The one over on the left is my son. He's also one of our paralegals. And the young lady on the right is our client services coordinator. That's Becky. She works in our law firm. All those daughters I have lots of son-in-laws also. And another reason I do this is I want to make sure the family is taken care of, mainly my wife. My spouse is taken care of should anything happen to me. So that's the type of planning that we do. We have a great team of people in our office that handle this, and we have a great backup of Lawyers with Purpose. So this is all about family. This is what most people want to know. I do a lot of these workshops, and folks have no idea what this is all about, but they do have preconceived notions about what this is about. So these are the questions that they commonly ask. Can I protect my stuff? Now, stuff is a highly technical legal term for stuff. You all have it. You all know what it is. Can I protect that from the government? Can I protect it from long-term care? And can I protect it from family? Now, why would you want to protect your stuff from family? We will get into that. And how do I do that? What is a trust? And what's the difference between a revocable trust and an irrevocable trust? How can I avoid probate? Do I need to? Can or should I give my stuff to the kids or to others, my house, things like that? And if I do give my stuff away, will it take 60 months for it to be safe? 60 months is that 5-year look back that everyone has heard about. That's a Medicaid rule of giving things away and creating a divestment penalty. What is a power of attorney? What's a living will? What's a healthcare proxy? What's the difference between these, and which one do I need? How can I plan for my disabled beneficiaries? Are my IRAs safe? Do I need special planning for them? Most people don't know that the law changed in 2013, and inherited IRAs are no longer creditor protected for your heirs, your beneficiaries. And the last question most people ask is, how can I avoid estate taxes? That is a current issue right now in our tax planning. Currently, each individual is allowed to give away $5.49 million. There aren't very many people here in this workshop that are concerned with that. And if we do see any, we'll talk about that in a special meeting just for you. So here's the goals of our workshop. We would like to identify if your current plan meets all of your goals. We call that all set. Am I all set? We want to understand what it takes to protect you, to protect your stuff. So don't try to learn all of the law. Just anchor to the stories that we're going to be telling, real life stories of situations that we run into every week. And our goal is to show you how to get what's missing. So, are you all set? As we work through this process, first of all, we need to know the rules. So the 3 steps to plan and protect your estate start with the rules. Then we need to know who your predators are to your plan. And then the third is to know your options. So let's start with knowing the rules. So how many of you folks know that the government has rules for you when you're alive? Everyone knows that. How about rules after you're gone? Well, they have those too. So there are government rules during your lifetime, and these all involve who has authority over your stuff, Who has authority over your decisions? Who has authority over you? Well, as you're all sitting here right now, you know you have authority over all your stuff, all of your decisions, legal and financial and healthcare. As long as you have capacity, you're in charge of all of your stuff. But what happens if suddenly there is no capacity? What happens if someone passes on? Now we need to make sure that we have a process that someone can step in that has legal authority, that has financial authority. If you have not passed on, we need someone that is there to follow your rules for your healthcare decisions because you can't. How about someone to make sure that when you do come to the end of your days, that your wishes are followed because you perhaps can't give those directions out anymore. So there's end-of-life issues that we have to deal with. So what would happen if you do not have any legal documents or legal powers established prior to that disability or that incapacity? Then we're looking at a court process. This is called guardianship, legal guardianship. That means that we have to go to court. That means that, for example, my wife and I, let's say we go out for a fish fry on a Friday night. Everything's great. It's wonderful. But rather than just going home after the fish fry, I decide to have a stroke. Uh-oh, what just happened? There I am. We got trouble going on, don't we? So my wife is going to call 911, and we're going to have a rescue going on. We're going to have EMTs. We're going to have the fire department. We're going to have lights and bells and whistles, and I'm not going to be aware of what's going on. But where am I going to end up? Or what are the EMTs going to do, the rescuers going to do when they get to the restaurant? Well, they are going to assess the situation. They're going to stabilize me, and they're going to move me. They're going to take me somewhere. Where would that be? Well, that would be the closest hospital, wouldn't it? Now, would that be the hospital I prefer to go to? Well, at this point, I really don't have a say, do I? So what sort of a doctor am I going to be in front of at this point? More than likely, certainly not my primary care physician, right? In a private room, that's not going to happen. I'm going to wind up in an emergency room situation, and I'm going to have an emergency room doctor. Now, that's different than your primary care physician. And what is the emergency room doctor's goal? Similar to the rescuers, they want to stabilize me. They want to assess the situation, find out what's going on with me. Now, obviously, that could result in artificial means to keep me alive at this point until they can figure out what's going on and go through their process that they have, depending on the hospital and the doctor. So at that point, that would be the doctor comes and talks to my spouse then after some time, and it's the good news, bad news thing. The good news is, Mrs. Ley, that your husband is alive. The bad news is we're having to keep him alive. That's a tough situation. And at that point, they're going to assess, is there legal powers available for my spouse to make decisions for me because I can't. They can't talk to me. And if there's not, now we have to provide those legal powers. Those legal powers are going to come from a legal process. We're going to court. That's what that means. So my wife will have to get an attorney. She will have to go in front of a judge. The judge will say, well, Mr. Ley has rights here. Also, we want to make sure we don't trample on those rights, so he needs an attorney also. That would be called a guardian ad litem. That attorney is going to be assigned to me to make sure my rights are enforced. We need two doctors then to say that, yes, indeed, Mr. Ley has no capacity. He cannot make decisions on his own. We need someone else to make those decisions. And then the judge is going to gather that data in. We're going to have a hearing. He's going to appoint tasks for the attorneys, and then he's going to set a date for a trial. Does this sound like fun yet? That's going to take some time. This isn't happening Saturday afternoon after the Friday night fish fry. This takes some time. So if we don't have the powers of attorney in force previously, and I now have no capacity, I also don't have capacity to enter into any new agreements or assign those powers to anyone else. So we're stuck with what I have at the time. And guardianship, you can tell, is probably not a good plan. But most people do not have any of these documents in place, so the government has to have rules in place for those that have done no planning. How many of you know that the government also has rules after you're gone? Your after-death rules. Well, we've all heard of a last will and testament, right? Well, who's in control? Who gets your stuff? You're gone now. So who are we charging to take care of things after I'm gone? Well, most folks think the executor is the person in charge, right? Well, that could be the case, but that doesn't happen automatically. In Wisconsin, we call that a personal representative. That would be a person that I appoint in my last will and testament, that upon my death, I would like this person to be in charge to carry out my wishes. So who is then going to get all my stuff? Where's all that going to go? Do I have a list of things in my will? Here's where I want this to go and that to go. What about my spouse? What about my children? What if there's children I don't want to get stuff? Now we have to provide the legal authority to that personal representative, be in charge of distributing the stuff, to be in charge of taking an inventory, to be in charge of understanding my wishes after I'm gone. So that doesn't just happen automatically. Now we're back in court. This is called probate. So this government process of probate, the judge is going to admit the will, meaning that the will should be done correctly under the Wisconsin statutes. At that point, then, they're going to appoint the personal representative. Hopefully that personal representative is the same person that you requested in your last will and testament, but it doesn't necessarily have to be. It's up to the judge. Now that personal representative gets appointed and is given the power to follow your wishes in your last will and testament. So that sounds like fun, doesn't it? And it also sounds like that happens really quick. Indeed, it does not. That legal process does give government control of how things go after you're gone. There is a delay. You don't just get in and get all this done. There's stacks of paperwork that have to be done. Prior to the judge seeing the paperwork, all the I's need to be dotted and the T's crossed. And it's also a very public process. In other words, I have to have an inventory taken of all my stuff, and that is a public inventory. These are the assets that will go through probate, and any person can go online. Any court process is an open process, and anyone can go online and look at that inventory of that probate and see what I have, what kind of stuff do I have, what's going through probate. This sounds a little costly too. Notice the cost spread there, 5% to 20%, according to AARP. The reason there's such a big spread there is $1 million estate takes the same amount of paperwork as a $100,000 estate. So there is quite a spread. And the reality is it is a lot of paperwork. There's a lot of I's that need to be dotted, T's crossed. Most of the time that's done by paralegals. The attorney reviews the process and paperwork prior to submitting it to the court. And the clerk of courts reviews the process prior to giving it to the judge. And the judge is then tasked with moving the cases through on that particular day. That is that process, and it can be quite costly and quite time-consuming, and it's optional. You can plan completely around probate. If you have a will, you will go to probate. What if you don't have a will and you have assets that should go through probate? Well, guess what? The government has rules for that too. That's called intestate probate. You have a will, you're going to probate. You don't have a will, you're going to probate. Those are your options if you have assets that pass by probate. Here we like to talk about the distinction between documents versus planning. Most of you, as we talk about these things, you can relate to documents that you've heard about, these power of attorneys, these healthcare proxies, this last will and testament. Those are documents. What we like to talk about is planning, estate planning documents, and we put your voice into those documents. This is your own rule book. How do you want things to be handled? Should you have incapacity? Should you be deceased? You want your plan followed. We run into this a lot with power of attorney for finances. There are statutory forms, and folks that I talk to say, well, what kind of a statutory form or what kind of a power of attorney do you have? You have the regular one, right? Well, most people are like, what do you mean the regular one? What is that? What folks don't know is that there are rules in every state, statutory rules, to make sure that the folks that have not done any planning, there's still things that need to happen after you're incapacitated or deceased, and they don't want these things settled with pitchforks and shotguns. So there are rules in case folks have not done any planning. And the fact is, it's a very, very high percentage of people that have done no planning. So what most people think is, what do the kids fight about after something happens? Most folks think it's all about money, correct? It's all about money and stuff. Well, it's not. The fact is, when we do have an incapacity issue, and we have healthcare decisions that need to be made, it's all about who's making those decisions now, who's in charge of things. Many families, you have kids that maybe they all don't live in the same town anymore. You have one child that may be more astute at financial things. You may have a child that's more astute with healthcare issues. So as a rule, families will put those children in charge of those things, and the other kids are left wondering what's going on. Now we have an emergency, and it turns into, you get the phone call from the child out of state. Well, what's going on? What's going on with mom? And the child at home, who happens to be in charge of healthcare decisions, says, well, here's what we're doing. And the child in St. Louis says, well, what are you doing that for? That's not what mom wanted. And that turns into a fight. And next thing you know, you have a child from another state getting their own lawyer to find out what's going on with finances, to find out what's going on with healthcare decisions, and it just turns into a mess. It's not a good thing. One thing most folks don't understand is that the agent or the proxy, the one that you've put in charge, it's not them making the decisions. Their job is to enforce your decisions. That's called planning. You want the power of attorney to have your wishes written down of how these rules are to be followed. This is what I want to have happen if this, that, or another happens. So the agent or the proxy is not making the decision. They're following your rules. We run into this a lot with the statutory powers of attorney. How much power does that agent have if we have to do planning that is involving moving assets around in an estate? If we don't have that rule written down and authorized, we can't do that kind of planning. If we do need some emergency planning, we may end up having to do a guardianship anyway, even if we had the proper document in force, and then we're at the mercy of the court for any type of planning we may want to do. The other thing we run into are documents that have too much power, what we call a super blank check. We're allowing our agent to do more than is required based on our rules, so we want to make sure that we have language and planning your rule book in place that says, here's what you can do. You can move assets around to qualify me for Medicaid so that my surviving spouse is not left with nothing, so that we don't go broke because I may end up in a nursing home. We would prefer you have a document with planning, your voice, that gives full authority with instructions. The other issue we run into a lot is the healthcare power that we're giving one of our agents, our children usually. Usually it's the spouse, then the children. We call it the God proxy. The God proxy is the agent has a right to pull the plug, correct? That's kind of a life and death situation, isn't it? I would rather have the rules down that if this happens or that happens, if it looks like I'm not going to be able to interact again with my family, if I am terminal, if I do have this condition or that condition, it's okay to let me die. I want the end of life rules written down in there. Typically what happens is if we don't have those rules written down, then we defer to the doctor or the state. That's called loss of control. So what we like to do, we call it second crack at the apple. We are going to allow our agent to make decisions, but we're going to give them some time to do that. Perhaps we want a second opinion on this terminal condition. Perhaps we agree that it's terminal, but we want some time to bring the family together to say their goodbyes before someone pulls the plug. We're going to say we don't want any of these artificial means to keep us alive. However, our agent can use all of those very same artificial means to keep us alive, but for X number of days, 5 days, 10 days, however long we decide, or sooner should that decision be made, then the plug gets pulled. We're staying with these are my wishes, not my spouse or my children's rules. They need to follow my rules. Our form needs to also have information about organ donation. We want to make sure that the document itself is HIPAA compliant, or they do indeed not have to follow it. And the end of life issues, our plan there is keep control of things. We don't want to turn things over to the doctor or the court. We want to tell the doctor, we want to take the liability off the doctor that if I am indeed terminal, it's okay, doc. I do not want to be sustained. I do not want artificial means to keep me alive. And it's okay to make this process painless for me. I would like that in writing. The idea there is we take the liability off the doctor that these are my wishes, and I would like my wishes followed. And doctors love that. Another process that we do is called a personal care plan. It's an excellent document. This would be if I'm in a position where I'm in a nursing home or I'm in a facility and I cannot express my wishes on my care, I would like this in writing. This is the care I would like. These are the things I would like to watch on TV. These are the things I would like to do if I can, if I have the capability. I like to go outside. I like to go to public places. These are the things I like to eat, or more importantly, these are the things I will not eat. Don't put this in front of me. We find these documents to be extremely useful to our clients when they're in that position, and the healthcare providers love these documents, especially if there's dementia or memory care issues involved. It tends to keep the patient, me, calm when I'm being treated the way I'm used to being treated. And the CNAs and the other LPNs and the other folks that do the hard work of providing that care find that they get better results treating the client with the care that they normally would experience at home. The other document that we want to plan around is that last will and testament. We already touched on the probate process, which is an optional process, which is something most people do want to plan around. Section 2, we need to know your predators. What kind of predators do we have to our estate plans? Well, there's government predators, there's long-term care costs, there's your family, and there's lawsuits. Let's talk about government being predatory. We've touched already on the guardianship, not a very good option. We've touched already on probate, not a very good option. But what about taxes? This can be an issue. Again, not very many people currently have more than $5.49 million. Each individual is allowed to give that away in their lifetime before there's any federal estate tax. However, if you do have more than $5.49 million as an individual and are presented with an estate tax issue after death, then most of those folks also have IRAs, and the reality is estate tax percentage starts at 40%, and then you have tax on IRAs also. You can actually get up in the 70% range where you thought a lot of your assets were indeed going to your loved ones, but Uncle Sam jumps in between and takes a significant amount of that money away. State of Wisconsin is not shy about that either. If you do have estate tax issues, state of Wisconsin will get their share also. One issue that most folks aren't familiar with is the capital gains or the step up in value. When an heir inherits property that has a capital gains basis, upon death it steps up in value. What we find is some planning that people have done previously, selling the house to the child for $1 or gifting assets prior to death. When you do gifting, you also gift that cost basis over to the recipient. In other words, if I bought that house for $25,000 40 years ago, it's now worth $250,000, and I gift that house to my son to protect it from Medicaid. Upon my death, my son may want to sell that house, and when he goes to sell it, he's going to be surprised to find that the cost basis of $25,000 stayed with the house and the gift, and that child will be subject to 15 to 20% capital gains tax, which they weren't planning on. That can be a rude awakening. Long-term care cost. How can long-term care costs be a predator to your estate? Well, as you can see with these numbers, it can be quite expensive to self-pay for long-term care, whether it be a nursing home, assisted living, or indeed staying at home. Now, you don't have to like it, but this is the way it is. So who's paying for it? Well, everyone wants Medicaid to pay for it. So what are the rules for Medicaid? Medicaid. What in the world is Medicaid? Have you heard with Medicaid that they can take your home? Have you heard with Medicaid that you have to give your assets away to protect them? And if you do give your assets away, you have to wait 60 months to qualify. That would be the 5-year look back. Well, indeed, Medicaid is a complex set of rules and exceptions. In fact, there are exceptions to exceptions to exceptions. So let's dig into that a little bit further. The state of Wisconsin, in addition to Medicaid rules for receiving it, also have a estate recovery program that was implemented August 1st, 2014. What they've done here is if someone receives Medicaid prior to death, in other words, you wind up in a nursing home and you've spent down to basically nothing, and the state of Wisconsin steps in and Medicaid pays your long-term care bill for the facility. When you pass on, there's an outstanding bill, and the state of Wisconsin will come looking to recover that money. They changed that law August 1st, 2014. As you can see, it pretty much covers everything now, right down the line. Joint tenancy property, that's with your deeds. Joint tenant with the right of survivorship, they can step in there, put liens on property. Life estates, we used to plan with those years ago. That now is gone. Wisconsin is a marital property state, so they've used those laws to also recover assets from the marital property. We used to be able to use revocable trust because the estate recovery program required assets to be recovered from the probate estate. So we would use revocable trust, which eliminate probate. They took that rule and changed it. We no longer can do that. They also will add liens on property. So even single people that, although the house is exempt, once you're approved for Medicaid, and Medicaid is actually paying the long-term care bill, they will start processing a lien on your personal residence as you receive benefits, and that will be recovered when you've passed on. And just to be sure, they also added other non-probate property, which is everything else. They can just come in and look for everything to recover, including life insurance. So these are state of Wisconsin rules, and again, they've changed these dramatically to make sure they can recover their assets. And the only way to plan around this in the current law is with irrevocable trusts. So we've all heard about these things. I call this beauty salon law and barbershop law, about them taking your home and giving things away in 60 months to qualify. None of those statements are true because of the complexity of Medicaid. So aren't you glad you heard about this? So we'll dig into the rest of the story, but I'm not going to cover this right here and now because of the complexity of Medicaid. And if anyone tells you that they can teach you this in a workshop, or any lawyer says that they can do this in a workshop, they're basically out of their mind because this stuff is extremely complicated. We'll get into that a little bit later. Unanticipated or unintentional predators. How can your spouse in a blended family be a predator to your estate? These are things that most folks don't think about, and in many cases, their documents don't address these issues. This is where it's very important to have planning in your voice in your documents. Blended families, everyone knows what that is. A lot of you folks have been married for a long time, but when someone passes on, there may be a remarriage that happens down the road. And when that happens, that changes everything. Where is your stuff going to go? The decedent. Where's the decedent stuff going to go? Especially if your spouse gets remarried. In most cases, in a remarriage or blended family situation, there are kids from a previous marriage involved. So there's stepchildren. And if you haven't done any planning, Wisconsin being a marital property state, the spouse that passes on, the new spouse is going to inherit everything. And at that point, your stuff could very well wind up going to the stepkids rather than your own kids. Folks do not plan on this. That's certainly not what most folks want. So you do have to have your voice in your plan to handle this. The other problem we run into is long-term care costs for a spouse. If I have a significant IRA and I am the community spouse, in other words, I'm not the spouse in a nursing home, but my wife is in the nursing home, and I get her qualified for Medicaid so that I'm not wiping out my estate. What happens to my IRA if I pass on and my wife is in a nursing home? Well, most folks have spouses as beneficiaries. So if my IRA goes to my spouse at my death and she's in a nursing home, that can really make a mess of things. That is an option that can be planned around also. A lot of our clients do have children, and if they don't have children, they do have beneficiaries, others that they would like to receive their stuff when they're gone. And we run into these problems quite a bit, where you have a child that perhaps isn't very good with money. The old adage, you give them a nickel and they spend $1. Well, these days, you give them $1 and they spend $15,000. Or the child that accidentally is forced into bankruptcy from a poor decision or a business failure. These days, we also are faced with addictions that can dramatically change things. It would be nice to have language in our plan, our rule book, that says if I do have a child that has addictions, then I want the access to these assets, my assets, turned off until that trouble is gone. We also include supplemental needs trust or special needs trusts with our plans because we never know if any of our beneficiaries are our children or our children's children that might receive our stuff would be disabled or actually have a need for health care from the government. If those children or disabled adult children received inherited funds, that disqualifies them from government benefits, and that can really be a mess. And it takes quite some time to get that back. And in that instance, your inheritance to that child can actually end up going to the state. Or we also have children that maybe have gone through a divorce. That seems to be over 50% of the people these days are faced with divorce situations. And if there are assets that are commingled, in other words, my assets that have gone down to my daughter, that she happens to commingle with assets of her current husband, and later on they get a divorce, then half of my stuff is now going to that ex-son-in-law that I had, and that isn't a very good plan either. The other thing we run into is when grandchildren or great-grandchildren, if I would like to give them something additional to help them with their education, that can actually interfere with any of their student loans or grants or any of the other things they might receive from being that smart little grandchild. So we work around that also. The other unanticipated and unintentional predator can be lawsuits. There's a lot of lawsuits these days. Anybody can sue you at any time. You can be sued individually, or your spouse can be sued, or your beneficiaries can be sued after they've received your stuff. The planning that we do protects from lawsuits immediately. When we prepare an irrevocable trust to protect your assets from nursing homes, that also protects your assets immediately from lawsuits that you might run into. So what do we do about all this? So slide number 16. What do we do about all this? You need to know your options. So what is estate planning? There's 3 core elements to estate planning. First one is who is in control. Who is in control when you're alive and well? Who is in control when you're incapacitated? Who is in control when you're gone? And what about your spouse if she becomes incapacitated? If she or he gets remarried or they pass on? And then, of course, who's in control when your assets go to your children? Who gets the benefit of your assets when you're alive and well? Well, hopefully me, right? Who gets the benefit of your assets when you're incapacitated? What if we have to do some sort of planning to make sure that my spouse is not going to become impoverished should I wind up in a nursing home? How about when I'm gone? Do I want my assets protected as they go to my wife for her as she continues to live on so that she doesn't have a dramatic change in her style of living? Would like that done. What if my spouse then becomes incapacitated after I'm gone? What if she becomes remarried? What happens to my stuff after she's gone? We want our own rule book to control these things. And then, of course, ultimately, I want what's left of my stuff to go to my children. There's a lot of things that can interfere with that, so we want rules that are going to cover that and protect our stuff. These are the typical goals of an estate plan. This is what most people want. Number 1, they want to stay in control. Number 2, they do not want to become a burden to their loved ones. And number 3, they want to keep it simple. So our goals for your plan is to know the difference between documents and planning. That's making your own rule book. And we want you to understand all of the costs and how to minimize them. There's a lot of things that can interfere with your retirement plan. And nursing home and long-term care is a huge one, not to mention the other predators and unintentional predators that we talked about. And we want you to know your options and to choose the plan that's right for you. Option 1, well, this is what most people do, is they use the government's rules. We talked about guardianship. That's a legal process that's enforced for those that have not planned. We talked about probate. That's what a very large percentage of people after they are deceased wind up in the probate process, which can be quite cumbersome, and also estate administration. Those are the government's rules. How do things move through your estate to the beneficiary, to the heir? Those are government's rules. Option 2, how do we protect from long-term care costs? How do we minimize the cost so that you can afford the care that you desire? There's a lot of different ways of doing this. Of course, we talked about the costs of nursing home, staying at home, assisted living, or actual 24/7 nursing home facility. Well, you can privately pay for that. You can transfer the risk away from your estate to long-term care insurance. That's an excellent option, but most people have not done that. It can be quite expensive, and you have to qualify for it. We also have community Medicaid and Veterans Aid and Attendance plans that are available. Virtually everyone can qualify for these plans within 30 days if we've done the pre-planning. We can also use Medicaid to cover the costs of long-term care so that your spouse does not become impoverished and that your family does not go broke in a nursing home. So let's talk about a couple of real live cases. We're going to introduce you to Mary Smith, and we're going to take a look at the Richards in pre-planning. Let's start with taking a look at the rules. These are the government rules and the state of Wisconsin rules for Medicaid. You can see there's a lot of numbers and a lot of stuff there. This is very complicated. We don't have time to go into each and every one of these issues in this type of a workshop. But you can see that there's divestment penalties, there's individual resource allowances. These are the rules that the government allows you to prevent your spouse from becoming impoverished. They're very strict and, in my opinion, too strict. So we need to plan around that. So here's a real life case. Meet Mary Smith. Mom has to go into a nursing home. So Mary has called the office, and she is in charge of figuring out what are we going to do now. They have a house, they have a car, they've got some cash, and they've got some investments. So she has to go in the nursing home. So how much did you think Mary thought that the family was going to lose in this case? Well, Mary pretty much thought they were going to lose almost everything. She did have a discussion with the family lawyer prior to talking to us. And what did that lawyer tell her? Well, that lawyer told her about the rules that Medicaid has and that they were going to lose pretty much everything except $122,000 thereabouts. And that sounded pretty draconian. So what did we tell her? Well, we told her that mom and dad would qualify for Medicaid immediately and they would lose nothing. The reason for this is due to their income. One of the exceptions is we can exempt certain non-exempt assets to create more income for the spouse at home. In this case, dad was at home and his income was too low to be able to maintain the house. So we were able to exempt other stocks and investments to create more income for dad, to make sure he does not become impoverished. And we were able to protect the entire estate. What if you plan now? What if you're healthy? So here we'd like you to meet Mr. and Mrs. Richards. So this is a typical couple that we deal with. They're age 75 and they're currently healthy. They have a home, they have cash, they have a car and other assets, and of course they have stocks and investments also. Their entire estate is $577,000 currently. So the question is, if they give their assets away now, how long will it be until they could qualify for Medicaid? Well, the typical answer there is 60 months, right? 5 years. Well, could they have protected their assets sooner? Well, let's take a look at that. The typical plan we would use for pre-planning for the Richards, the way they are set up now, all of their assets are at risk, $577,000. Now, with the plan, once we implement it, we immediately protect $449,000, which leaves a balance at risk of $128,000 for 37 months. Now, after the 37 months, if Mr. and Mrs. Richards are still healthy, we then protect $3,459 a month until month 60 when it's all safe. We all have our own numbers, and these numbers are dependent on the type of assets we have, our age, our health, and the type of planning that we're able to do for our clients. So how do we do this? How do we protect our stuff? With the right trust. That's how we do it. There are many different types of trusts. Trusts require 3 parties to create them. You have a grantor that makes the trust. You have a trustee, that's a person that's in charge of the trust. And you have a beneficiary. That's a person that's going to receive the benefits of the trust. And each individual can be all 3 of those. The type of planning we do, there's revocable living trusts. Revocable living trusts are an entity that we put assets in. Any assets that are controlled by the trust will bypass probate. Now, we can put assets in and take assets out of a revocable living trust. That also means that the nursing home would have access to any assets that are in the revocable living trust. We pair that with what's called an irrevocable trust, or what we call an income trust. That trust, the principal assets are protected from predators and creditors. In other words, the nursing home would not be able to access assets that are in that trust. If we go back to Mr. and Mrs. Richards and think about that, we looked at the months. Once we have an asset in that irrevocable trust, and it's in for 60 months, it would be protected going forward. Prior to that, depending on other assets that are held outside of the trust, we can protect at least half of the assets at any given time. So asset protection is a very important part of planning to make sure that your rules are followed and that your plan is implemented and that your spouse and your heirs will have assets left regardless of the situation. We also have irrevocable tax planning trust. Now, that's not for most people. That would be for folks that have over $11 million. It's the same type of planning. We just add another layer of planning on that. And you notice that we have a picture of a little red wagon there. That's what this is all about. That little red wagon represents our trust. And how do we hold assets? Do we hold them in revocable? Do we hold them in irrevocable? Do we hold them in both? That's the key. And everyone has their own rules. Everyone has their own wishes. And that's part of what we do. So how do you create your own rule book? Well, you want to get your voice there, and you want to plan it actually works. So we decide based on the design of your plan if we're going to use trust, if we're going to use testamentary trust. Then we need to integrate those rules with your life and your stuff. And then we have to maintain those rules with your life and the law changes going forward. One of the things that we run into a lot are good marketing versus good lawyering. Typical trusts are just documents. We've talked about documents and your rules. In other words, it's not your rule book. Typical trusts require 2 doctors for incompetency. That's an optional thing. We do not need that. That's a boilerplate type thing. We can plan around that with your own disability panel. Typical trusts are not funded. That is an issue that we've seen many times. If we do not have our assets integrated into our plan, then we will go to probate even if we do have a trust. And typical trusts also give assets out to beneficiaries without holding them in trust in case anything should happen to our spouse or our children. We want to make sure that those assets are protected even when we're gone and it goes to them. So you have to be aware of that we do that syndrome also. We run into this a lot of times. This type of planning is very unique. That's why we're proud to be associated with Lawyers with Purpose. These trusts that we've been using have been around for many, many years. They get modified as the laws change going forward. Asset protection is a very unique type of planning that involves federal law interacting with state law. The other issues are the new planning that needs to be done with IRAs, and our trusts do address those issues. Having your rule book is the first step. Then you need to integrate it. We talked a little bit about integration. Integration means that the trusts that are created need to hold the assets. In other words, the assets need to be titled into the various trusts so that we can avoid the probate. If there is no integration, then there is probate. So we have to get our assets into our little red wagon. We have to make sure that the revocable trusts pour into the irrevocable trust, and at the irrevocable trust, the proper assets are in those. We also have to integrate that with any IRAs that the spouses have to make sure we have that planning done correctly. We have to make sure that any joint accounts, whether it be real estate or bank accounts or any documents that have beneficiary designations, life insurance, annuities, things like that, or any of your bank accounts or investment accounts that have pay on death, transfer on death, or in trust for designations, that they are integrated into the trust, or we just have a fancy document that doesn't do anything. That's all integration. We take care of that for our clients. Question is, once I create my rule book and integrate it, am I finally all set? Well, we hope that we are all set, right? But that all depends because things change. Families' dynamics change, our finances change, certainly our health changes as we get older, and the law can also change. So are we all set? Well, we do need to maintain it. Maintaining your plan, maintaining your rule book. This is our TLC plan, which stands for Thorough, Lifetime, and Complete. And this is a plan that we put in place because of law changes in 2016. Now all of our clients have the option and a fee guarantee program that allows you unlimited access to us and any of our professionals that we work with. We provide quarterly newsletters. We have a private website. We have an annual update because we do need to know and keep track of where your assets are, how they're doing, how your health is, how your family's doing. We have social events to stay in touch and make sure we're all on the same page. We also have an option that when we settle your rule book, that we have a fee guarantee. Our trusts are designed for your beneficiaries to settle themselves, but some folks don't want to deal with that. They would prefer to have a lawyer settle their estate, so we take care of that. So this maintenance plan is an annual program that we have found people are delighted with. So the goals of this workshop were to identify if your current plan meets all of your goals. In other words, are you all set? And to understand what it takes to protect you and your stuff. We anchored this to the stories that we talked about. There are a lot of rules and regulations that are involved with this. It's impossible for individuals to know all this stuff if you don't work with it every day. And our goal was to show you how to get what's missing. Well, that was the easy part. So to protect your stuff in 3 easy steps, you have to act. That means you need to assess your needs. You need to create what's missing. If any of the things we talked about you feel you need in your plan, that's where we would help you create your own rule book. And then we need to tie your rule book in with your life. In other words, integrate the whole plan. How do we do this? We have what's called a vision meeting, a complimentary vision meeting for our clients. And what that involves is you bring in your current documents, and we will review these stories and assess if you have them and if you want them, so that you do indeed know you're all set. We'll provide you with your own Medicaid numbers. That's the Richard story. What are my numbers? Can I protect my stuff? What does that look like? And then we will provide you 3 options to create what you have missing. So I'd like to thank you for taking the time to listen to this. And if you did find this helpful, please share it with your friends and family.